Ladies and gentlemen, good evening once again. Welcome to this evening's session, online mediation beyond Zoom mediation at the Africa International Mediation Week. Today, the 30th day of November 2020. We commence this particular session by reciting the words of the Kenya National Anthem in English. O God of all creation, bless this our land and nation, justice be our shield and defender. May we dwell in unity, peace and liberty, plenty be found within our borders. Ladies and gentlemen, once again, welcome. And I would like to invite Roger Moss to be able to take us through.
Well, good evening, and it's a pleasure to be with you. My colleagues and I are deeply grateful for the opportunity to be with you today. And in this session, Ismail Rahimian will lead us through the comments and questions and hopefully active dialogue with everyone about our experience in the online dispute resolution world. So I'm a mediator. I'm an attorney by training, but most of my work was in the area of commercial real estate transactions and lots of landlord-tenant work all over North America. And I use that experience now to prevent homelessness through a program of very innovative mediation practices. And we designed it with online dispute resolution at its center. And we're in San Francisco, California, and we've saved some 3,000 people from homelessness in the last few years. And the people that do all the work are my colleagues, Tonya, Saheli, and Ishmael, who I'm going to ask to introduce themselves to you, and then Ishmael will lead our conversation.
Hello, everyone. Good evening. It's really great to be here with you all. My name is Tonya Saheli, and I'm also a mediator out of the San Francisco Bay Area. I work with Roger very closely through the Bar Association of San Francisco. It's my pleasure to be here today to exchange ideas about how to better position ourselves in the area of housing mediation, and to share ideas with you about online dispute resolution as well. Ishmael will be driving this particular presentation, but Roger and I will also provide presentations later on this week.
Thank you so much, Tonya, and welcome everyone. My name is Ismail Rahimian. I am a mediator, also a consultant with the Conflict Intervention Service of the Bar Association of San Francisco. It is a pleasure to be here with you today. The subject for today is online mediation beyond Zoom mediation. We are scheduled your time till 10 p.m. Given that our group is a little smaller, I am wondering if we just can go around briefly, and if you would be kind enough to, if it's okay with you, to turn your video on, if it's possible, but definitely your audio, and sort of just briefly tell us about yourself before we get started. And this is voluntary, so if you wish to do that, that'll be wonderful. Would you be kind enough, anyone, to go ahead and tell us a little bit about yourself? Thank you, please.
Hi, my name is Kimutai Chirono. I'm based in Nairobi. I'm a trained mediator. I've been doing it for about 4 years. I came out of the property sector, so I'm very interested in, I was doing property development, but I'm very interested in using mediation to cater towards disputes between, let's say, the construction team and the property developer or the banking sector, etc. Mediation is not well known here in Kenya, so we're in the real expanding awareness to the public. And then, of course, having to also try and introduce them to online dispute resolution is like a double whammy. In other words, we have to try harder. So I'm very interested in learning everything to do about enhancing the process, which can be done online, and also about increasing awareness with the people who are considering disputes to utilize mediation. Thank you very much.
Thank you. Anyone else would like to join in?
Yeah, good evening.
Good evening.
My name is Pauline. I'm from Kenya. I'm an accredited mediator. I have a background in banking. So I deal with mediation in commercial and families. I was accredited in 2019. I'm really interested with mediation because of bringing, in my line of work, I've seen bringing families together. I work with Federation of Kenya Lawyers. It's a big organization in Kenya, and those are the people I deal with as we do the mediation. So I'm very interested. This evening, I want to hear more from you. Thank you.
Thank you so much for joining us. We also have the chat room. In case you have any comment or question throughout our conversation, please go ahead and put your comment in chat. Also, the easiest way to identify if you have a raised hand would be through the participants. If you can digitally raise hand, then we can address you as well. Thank you so much. Anyone else who would like to say a few words before we get started?
Good evening.
Good evening, Sabina.
Yeah, my name is Sabina. I'm in Nairobi. I've been lecturing for the last 10 years. I'm a counseling psychologist, and I found mediation to be quite closely related to counseling, and I'm quite interested. I've been doing court annexed mediation, and I would like to do more. These days, we have to do a lot of things through Zoom, and I thought I would learn more during this session. Thank you.
Thank you so much, Sabina. Anyone else would like to chime in? Probably not. So how I like to open our conversation today, I'm going to share a screen with you. Bear with me here as a co-host. And please be patient. Our bandwidth is not that as strong, so things take a little bit longer to load, but be patient with us. I would like to start and open up with approximately 3 minutes talk.
I am not getting any audio. Is anybody else having that same problem?
Yes.
Yes, no audios for me.
I'm sorry, do we have a problem with audio?
Yes, there's no sound. There's no sound. Ishmael, I was reading the captions here. That's how I was following along.
Okay, I'm not sure what's causing the problem because I do have the audio pretty much blasted. I'm gonna take a look at the sound setting here again. The microphone here, bear with me. And tell me if you can hear now. Cannot hear them?
No.
Please bear with me as I close the my link on the presentation. And again, accept my apology for the audio. I'm not sure what caused the problem, but luckily we did have the caption so that it may not have had the same effect, but the message hopefully was delivered. We're going to go ahead and start with our presentation on online mediation beyond Zoom. Please feel free if you have any questions. This is going to be in a conversation format. You can interrupt anytime if you wish, if you have a question. You can also go ahead and put your questions on chat. I would ask my colleague Roger and Tonya to monitor the chat room and so that we can make sure we address if any questions or comments you may have. For the next 90 minutes, what we're going to be delivering will be the online mediation, the ODR. So that is the acronym we're going to be using a lot, ODR itself. And to understand where we're going to go beyond Zoom, it is important to note that we need to know where we've been with ODR and where we're going, where we are today, and how the future would look like in terms of ODR. Let me see, I've lost my video here. Hang in there with me, thank you. So we'll look at, we'll define ODR. We'll look at the channels of communication within the ODR. We'll look at the benefits and limitation of ODR before we look at the system design in terms of access to resolution, access to justice, and of course, ethics in ODR, the guiding principles. And on these principles, we look at what is being published by ICODER, which is the International Council for Online Dispute Resolution. And as an example of what ODR can look like, and although there are so many examples nowadays, we'll look at one, and that is the Civil Resolution Tribunal out of Canada, the CRT. We have a short video on their Solution Explorer, and then we can dissect it, how a case is normally handled through CRT, from starting and applying online to responding to dispute, moving to negotiation, and this needed facilitation will follow before a decision is rendered by CRT. We also look at the success of the program in terms of the number and statistics, going back to 2017, where they started with 49 cases on ODR, closing 49 cases for their fiscal year. And this last year, between April 2019 to March of 2020, they had successfully closed over 6,000 cases. And that number should jump exponentially as it has done since 2017. Then finally, we look at ODR beyond Zoom, and we have some resources for you. Before we start our conversations, are there any questions that we can address? So let's start a conversation with a question of what is online dispute resolution? Of course, online dispute resolution in the US, and let me qualify our conversation today will be specifically with our knowledge, what we have available in the US, and working with our colleagues in different parts of the world, such as New Zealand, Australia, and Canada mainly. And what we talk in terms of ODR is within that context of the knowledge base, as well as when we look at the future of ODR, we'll refer to what Andy Lee is doing in China. So as far as the ODR is concerned, it is not a new concept here in the United States, for sure. The work goes back about a quarter century. The pioneers are Ethan Cash, the godfather of ODR, and of course, the work that has continued through many other pioneers, such as Colin Rule, within not only academic, but also private sectors. So the future of ODR is actually very bright here, and definitely internationally, because what becomes available through technology, through internet, becomes available, and it erases the border. So we're very excited where ODR is going in the next 5 to 10 years, actually. For now, our ODR basically is the ADR, the alternate dispute resolution, plus the existing technology. The technology that's available to all of us and we employ is the internet. So arbitration, mediation, bidding that incorporates internet is what we define as online dispute resolution, or ODR. We communicate through website, through email. So our conversation could be synchronous or asynchronous. For example, when we're working through emails, we can do video conferencing as we are doing today. We can also use our smartphone to do instant messaging. And this is all part of our dispute resolution process. Resolving dispute generated online or offline. So in a nutshell, that is how ODR is defined. Any questions or comments?
There's a question in the chat box. It says, yes. Do we have a, can you hear me?
Can you hear me for a moment? Could you repeat, please? I lost you there. Go ahead.
It says, do we have a success rate statistic on the 7,000 cases conducted on ODR? Does it compete with in-person mediations?
That is an excellent question. I would address that when we get to the number, when we look at the number of cases, and then I'll be glad to provide you with the resources, which is a publication of the CRT itself. And it's a very extensive report that actually defines and answers the question. Any other questions, Tonya, that we need to, go ahead, please. Any other one?
I
was just going to point out that the second part of the question is particularly interesting, and we will get to it later. As we see questions that can be answered straightforwardly in the chat, we'll try to put answers in the chat. But I have a feeling with this wonderful group, the questions are all going to be pointers to real conversation. So we're not neglecting your questions. We're going to hold them so we can talk about them. We're going to have a lot of time for that. So thank you.
Absolutely. Is there anything else relevant to the ODR in terms of definition itself that we need to address at this point? No? Let me continue on with our conversation on ODR. The unique challenges are what we all have. At least in the US, I can say that what has expedited the process for us has been COVID, to whereas we have not had the opportunity to do the face-to-face mediation. Therefore, we had to, more and more of us every day, rely on technology in order to conduct our mediations. At CIS, Conflict Intervention Service of San Francisco, we had adopted Zoom mediation, for example, as an online alternative a long time ago, even before COVID. So for us to do the transition, we did not have any difficulty. But then when March came and we had restriction in terms of meetings and more restriction that are coming to us even today, we had no choice, most of us, but to go online. And at CIS, we had the opportunity to help many mediators within the US with Zoom in order to bring them up to speed so that they can utilize the technology. And we continue to do that work. We have made ourselves available to make sure that everyone who wants to have access and needs access can have access. However, when we come to the limitation, we should note that one of the limitation is access indeed, and we'll address that. So ODR is being proposed as a way we can continue to resolve disputes in this environment. How that impacted us and how much we have adopted the technology will determine how much more of this work we'll be doing online versus in person. Because now for many of us, we are realizing the boundaries have been erased. So physically we could not be somewhere in the United States or outside of the US. With the technology, we have the ability to connect. Therefore, we anticipate that in the future, even when face-to-face mediation becomes available, many people are going to prefer and demand that we continue with the online dispute resolution, not only because of convenience of it, but also because of the fact that the newer generation, in the US at least, the millennials, are more adept to using the technology than, for example, the baby boomers. So where do we even start? Let's look at some of the benefits. Bear with me. Briefly looking at the channels of communication within ODR before going to the benefits and limitation of it. What are some of the differences? We can look at that between mediating via video conference, audio conference, and through text-based communication. Again, it goes back to the question of access to technology. What technologies are available? Even in the US, we do have a certain population who do not necessarily have access to internet, or they're part of US, the people that we work with may not have a strong bandwidth, to whereas we can actually conduct the mediation on video conference. Therefore, at times we have to rely on probably a face-to-face, a WhatsApp on our smartphone, or even text-based, because some people prefer to actually have text us, especially when it comes to individual caucuses within mediation itself. To the question of in-person versus ODR, can you really effectively mediate an arbitrate dispute without meeting the parties in person? So that is a question we would like to impose to you as part of our conversation. And if we can hear your feedback, that would be wonderful. So we know the level of adaptation of technology within your environment. Anyone is willing to share? If not, my colleagues can always chime in. No?
Ishmael,
Tonya,
can you repeat that? Is this the question? Can you really effectively mediate and arbitrate disputes without meeting the parties in person? Is that what you're asking?
Yes, I'm asking our audience the question. We have designed some questions for our audience in order to get their feedback, for us to get a better understanding and appreciation of the environment in which they operate as a peacemaker. Anyone care to join in answering this question? No. Tonya, Roger, would you be able to speak to that just briefly if no one else is? Oh, someone was going to. Go ahead, please.
Yeah, Ismail, let me try to answer that question and say that in Kenya, this is a new phenomenon because we have not been, and I personally too have not been embracing technology before COVID. We used to believe on face-to-face meeting. It is changing with the time. Now we are appreciating this the technology because of, I can say it's because of COVID. I used personally to do mediation, one-on-one, but very rarely. But now I am sitting down on a Zoom, and we can have a conversation with the client, and we can conclude that. We fill our report and we finish it online. So I'm appreciating the technology now, despite the challenges which we have already now here because many people do not understand it. But I am sure with the time, everybody will be able to appreciate the technology. And I personally feel it's the best way to go. It is less time consuming because you just be doing it in the comfort of your office or in your house. And
Pauline, you're muted.
When you
Pauline, please go ahead. We lost you there for a few minutes.
Yeah, I'm sorry. I'm sorry.
No problem. Oh, that's perfectly fine.
Yeah.
Understood.
I was saying we are appreciating. I'm personally appreciating technology, and I've seen most of our colleagues really appreciating technology because now we can do mediation, on Zoom, and we can see the outcome. We can conclude everything on Zoom. So that is one way I can say we are okay. We are following you in the US, and those who have.
Thank you so much, Pauline, for your input. This gives us a better understanding, in your environment, how things look like when it comes to ODR. Although, we talk about it in the context in which we operate out of US, there is a common denominator. Initially, we had the same challenges. Mediators making a statement that it cannot be done through Zoom. Of course, we had to get a distinction later between can't and the statement, I prefer not to do mediation on Zoom. But as we go through more restriction and less availability of face-to-face, there was the adaptation sort of speeded up. And the work of ODR, the evolution of ODR itself, we have seen a massive growth in terms of the changes that's happening within that industry and the availability of different type of program, different platform that actually can handle dispute resolution. Thank you so much for your input. Let me move forward real quick to the next slide here.
Ishmael, we have a hand. Vangari's hand is up.
Yeah, Vangari, please go ahead.
Thank you. Yeah, thank you very much, Ismail, and good evening, and also to Tonya and to Roger. I'd like to chime into the inquiry that you've asked with regard to what is our experience. And I have a mediation as we speak now, where we are in a the clients, one is within the city I'm in, and one is out of the city that I'm in. The clients are not even on WhatsApp. They don't use WhatsApp as in their own day-to-day. And so I think I would also be quite interested to learn also on how that, let me say, other technologies that we can be able to make use of in such situations. And when I say this, it's also the situation with the vast majority of the potential clients. As mediators, just as my colleague Pauline has mentioned, we probably, yes, were caught, we just knew face-to-face, and hardly would you even say that you were even trying to manage even by telephone. So we understand, we know it as Zoom right now, but I think probably with your support in this discussion, you can also help us to understand just that whole landscape. But the situation, because I have clients and we are right now not able, we cannot do Zoom, we cannot do virtual at present. So also that's something, and maybe after you give the presentation, as colleagues, we can now think around how to serve such clients, because I think that will be our greatest majority. The second part of it is the experience of coming to start using the Zoom platform. It felt like the experience was like going back to school to study computers, and so for me, because I have an interest, because I would like to use it for, let me say, serving clients, plus also I use it for, I was using it before for studies, then I can see that I will take the time to take the learning curve. So also how we get the clients to take that learning curve so that they can be able to also use the platforms. I think that's also something else I see as a challenge, because for one of the clients, we were now exploring how they can be able to go to the cyber cafes that are in the area near to them. So yet again, the issues of, oh, is there issues of privacy and such. Yeah, but I really appreciate now on that other side now for the client, because as mediators, I'd say we are trying, but then also we have mediators who are not in regions where, like now, if it's internet connectivity that can be consistent and such. Thank you. Thank you, Ismail.
Thank you so much, Vangari. Definitely, these are some of the challenges that we also have in the United States. And that is, we're not immune from it. But what we have learned is that the hardest sales always happen within your own organization. So as mediators, we have to be convinced that indeed it works before we can convince someone else that it works. Roger may have a comment on this, I'm not sure. Roger, would you like to add something before we move forward? We'll definitely address it, no doubt, yes.
Well, thank you, Ismail and Wangari, for your comments. I don't know if, I'll tell you what I was thinking about, whether or not it directly connects to what was just said or asked, I'm not sure, but it is a very important thing I've learned about myself. Now, I mentioned my background was in commercial real estate negotiation, and I worked for a huge company in New York City. It was a retailer that had thousands of stores all over North America. And I sat in my office in New York City and made deals with landlords as far away as Honolulu and in all 50 states. And for 25 years, I did that entirely by telephone. And it's amazing how, just as a person who loses their eyesight or their hearing, the other senses become sharper. I didn't realize this at the time. I realized this when I became a mediator, that I had become really, really proficient at listening and hearing things, hearing silences, and through experiencing, being able to interpret them, sensing tension. All that is possible to do without a visual message or even being in another room with each other. Not as well, perhaps, although sometimes there are actually advantages to not seeing one another, and we can talk about that separately. So when my life changed and I decided to take my experience and use it more formally as a person who mediates and does related kinds of services, I started that process about 7 years ago. And I began learning about online dispute resolution, and I instantly saw the utility of it. I mean, it was just a natural for me. It was just adding video conferencing. And so I am one who, practice is essential. Knowing when to change up, the modality is essential. But I'll end my comments with two things, and we'll return to these later. But it's when I stop thinking, when I start to fully understand that we've been online for years, all of us, all the time. We're on the telephone, we're texting people, we're using all these technologies, and we use them to facilitate other kinds of work we do, including bringing people together to work things out, classically in an in-person kind of mode. And when I realized that all these things are connected, they're not mutually exclusive, but they're interdependent. And in our program in San Francisco, we have a 97% success rate in our cases. We know our cases best of all. And that's because we use the online systems to set cases up for success before we bring people together. Before COVID, 80% of our cases had an in-person session, but they were all set up and evaluated and worked with individual parties online by telephone and other ways, including Zoom. So it's for me, it's this mental shift. When I stop thinking about being on Zoom or on the telephone as any different than just trying to talk to somebody I bumped to on the street. That's when everything changes. Just as I've heard friends of mine that they're proficient in many languages, they say when they start to dream in the language that's not their native tongue, that's when they really get it and they start thinking in that language. And I'm so humbled by everybody on this call except me, who has incredible language proficiencies. So I would just encourage you all to look at it through this very broad lens of your own experience that you've already had. It's not my experience or Ishmael's or Tonya's. You've already got online experience. Just when you see it that way and embrace it, it will be transformational, I think.
Thank you so much, Roger, for that insight. We definitely, I'm going to speed through some of the slides a little bit more so that we at least give ourselves 30 minutes, maybe more, so that we can actually have these conversations. And to address it even further, I put it down as a question for us to visit once we're done with the PowerPoint presentation. On the benefit of ODR, we know that we can resolve dispute both generated online and offline. It is more inexpensive because we don't necessarily have to commute, we don't have to rent a room, we don't have to make a room available in order to do face-to-face as far as travel and costs are concerned. These are some of the costs. Not only save us time, but also parties feel that they have more control. Privacy is another issue, and we, when it comes to ODR, we cover ourselves with a confidentiality agreement. We have at CIS, we have made sure we have added all the details in terms of having another person in the room, recording the session without authorization, or being in touch with another party who is not authorized to be part of the mediation. These are all issues of privacy that could be addressed within the confidentiality itself. Definitely, it is a question when it comes to ODR and privacy, and it's something that extensively needs to be evaluated, needs to be covered with the parties, with all parties involved, and also documented through the confidentiality agreement itself. And naturally, the more of it we can do in terms of online, we take in the pressure off of our judicial system. And definitely, the future is bright because when other platform comes in and more of those cases could be closed through the platform itself, naturally it's going to expedite the process and make it much easier to go through the court system rather than having a backlog. Continuation of benefits, it increases the access to justice, access to resolution. It can resolve the dispute between parties, different countries and different continents, as we are right now. We are a good example of it as we video conference, something that in the past, if we didn't use teleconferencing, would have required travel to be with you face to face. But then again, we are able to do that through teleconference, and we can do that with our client as well. Keep in mind, again, with respect to what Vangari said earlier, it is the adaptation that makes the difference, not having the best service. Is how we adapt ourselves to the technology that makes us successful. So this dispute can be settled, again, 24 hours a day, 7 days a week. And as ODR moves into machine learning and deep learning, using the smart contract through blockchain, for example, computer can generate those a lot faster than we can do as human. However, our skills and mediators are going to be required to be operators of those systems to assure integrity of the process itself. And like face-to-face on the ODR, we don't necessarily need to have an attorney, but we are doing mediation in the US where attorneys are actually present on Zoom. So not necessarily needed, but if they need to be there, they are there. Again, much like face-to-face, it's a voluntary process. So we cannot really force one party to join. We cannot even force them to do ODR because they may still have a preference of doing the face-to-face. But then again, are they willing to wait until such time that we are available and we have the means to be able to sit face-to-face with them in a room? Privacy, like I said, it's a part of the limitation we have. And then enforcement of the contract is another one, which we have resolved some of those issues at CIS through the follow-up that we do with our hub request that comes to us. So it has been said that also ODR takes away some of these face-to-face dispute that we have in terms of emotion, in terms of the tone. But then again, as we are learning more how to do mediation on Zoom, we are overcoming some of those limitations. And of course, the technology of Zoom itself is helping, and the future technologies in terms of giving us tools to be able to better communicate with a nonverbal communication. But for now, it's on us, the mediator, to be able to pay attention to the body language of our parties and be able to address, depending on the style of mediation that we do and the context of the mediation itself. Repeating player biases, and then, of course, the biggest one is the limitation of access, because we do understand not everyone has access. But as Roger mentioned, still we have a telephone, still a phone call is possible. So for those of us who have a strong auditory channel, rather than being mostly visual, it is easier for us to be able to conduct those conversations through phone. But then again, we have to keep in mind that as mediator, some of us have a preference to be able to see other people, to read the body language, and also for the clients to be able to see us in order to communicate better with us or more effectively. So how can we design an ODR system that are effective? As an example, we have brought into you today CRT, the Civil Resolution Tribunal out of Canada, and we'll go over as an example with you in terms of a system design, which seems to be one of the more effective among the packages or the platform that we've actually evaluated ourselves so far. And what disclosure and grounds rules need to be established before you start an ODR process. For that, we rely on iCoder, and I'll go over those with you. And if you need it in detail, I'll be glad to send those links later to Vangari, who can actually distribute those information and share those with you. How can, when it comes to access to resolution, then we need to address the question of how can you leverage technology to increase efficiency of your mediation process? And as Roger qualified it earlier, it really is a matter of practice. The more of those online mediation that you do, the more of an expert you become. We do run practice session. So prior to mediation, maybe a day before, we schedule a meeting with a client to make sure that they're comfortable with the technology, that the technology is working actually, and that what should they expect, and what do we expect of them through the process. So actually, when we go into the mediation itself, we have overcome some of the challenges. We've addressed it privately, maybe days before the mediation. And what new capabilities that ODR brings to mediators in terms of facilitating the mediation itself. There are many tools available out there. For example, there are platforms such as a Smart Settle out of Canada, which does, some of you may be familiar with, that does blind bidding. So if there is a financial dispute and the clients cannot come up to an agreement, the machine actually can make some sort of decision using algorithm in order to facilitate the discussion when it comes to the monetary dispute, and also at a higher level that can be done also in the issues that are not related to monetary issues, and more of a dispute, such as community mediation. So there are programs out there, there are platforms out there that can help facilitate and assist the mediator in the ODR environment in order to move the conversation forward within the mediation itself. Can ODR really provide a fair process to both parties? And what if one party is more comfortable with technology than the other? Some of these questions are still being answered when it comes to the system design with ODR. if you ask Andy Lee in China, he'll tell you that yes, ODR definitely can be a fair process to both parties, and China offered that technology through the virtual courts. So not only the robot is involved in facilitation of the mediation process, but also the virtual courts allows the parties to attend the meeting with a judge and be able to get a decision. On the principle in the system design, definitely we have to consider the question, what are the guidelines, what are the ethical principles that govern the use of technology in order to resolve disputes? That is an important question, and of course, iCoder is the pioneer in terms of the development of these processes to be adapted internationally. So briefly, when it comes to accessibility, and I'll read to you from the iCoder standards, and I'll be glad to share those links later so you can read through them and actually visit iCoder if you have not the website in order to get an insight of what is really happening in the ODR universe at the moment. So in accessibility, iCoder believes that it must be easy for parties to find and participate and not limit the rights to representation. In accountability, ODR system must be continuously accountable to the institution, the legal framework, and communities that they serve. On the competency, ODR system must be continuously accountable to ODR providers must have the relevant expertise to dispute resolution, legal, technical execution, language, and culture required to deliver competent, effective services in their target areas. Confidentiality, ODR must maintain the confidentiality of parties' communication in line with policies that must be made public and how the data are used. And that's a big issue at the moment for us in the US. As we work with technology in other countries, definitely for us it's important that there are regulations that require those data to be intact. Then again, of course, there's a question of how do we secure those data and what medium do we use in order to assure the security of the data and the integrity of our data. Fair, impartial, and neutral, ODR must treat all parties equally in line with due process without bias or benefit for an organization, individual groups, or entities. On the legal, ODR must abide by upon upload the laws relevant in all jurisdiction. And on secure, ODR providers must ensure that data collected and communication between those engaged in ODR is not shared with any unauthorized party. And transparency, ODR providers must explicitly disclose in advance the form, the forcibility of dispute resolution, the processes, the risk and benefit of participation, and the data must be gathered, managed, presented in a way to ensure it's not misrepresented or out of context. Again, I just want to briefly review those with you in terms of standard when doing a system design with respect to principle, the ethics and guidelines, but I'll be glad to share that information and the links later if you would like to read more about it. Bear with me as I move. So as an example, we briefly take a look at the CRT, the Civil Resolution Tribunal, and their process. If you have a chance, you can go to their website and take a look and walk you through it. As a reference, I have used the information exactly as it appears on the website without any altercation in order to assure the copyright of the information. And it's been disclosed that it is coming from their website. They start with an intake where someone applies for a dispute resolution. Automatically, the respondent are served with the dispute notice package, and the respondents are encouraged to submit a response The dispute then moved through the process of negotiation, facilitation, and if needed, CRT can make a decision. And later we'll look at it. What if CRT does not make a decision? What happens? I'm hoping the audio would be okay, but if not, this next video that I have for you walks us through. Again, I apologize if audio was not there, but then again, we'll break it down. We'll go through everything that the video sort of spoke of in a little bit more detail. Again, it's coming from CRT itself, and CRT is built on the concept of simplicity being the ultimate sophistication. And it is important to note at this point that CRT, from our conversation with CRT, we understand that the future of CRT will be the machine learning and AI incorporated. Roger, please go ahead.
Well, I have a question for you and everybody else. I found what we just watched to be incredibly effective without sound. And I'm wondering if anybody else experienced it that way. And it's an example to me of what I was referring to earlier, that sometimes what starts out to be a kind of a disability actually gets me much more focused on the message. Of course, that was an incredibly well done message, but does anybody else have any thoughts about that or response?
I tend to agree with you, Roger. I think that as humans, we are highly adaptable to our circumstances. And without the volume, I was able to follow along and could probably even repeat to you what the video showed even better, because I didn't hear it. I was focused very intently on it. So I agree with you.
Well, having that technical issue today, for which I apologize, actually, in a way, maybe is a blessing to show us that although there might be disadvantage of not having the sound, but then again, we can focus on what is on the screen, follow the message in writing, and be able to get the message, maybe at some level deeper than we did if there was an audio, for example.
Can I just also add, Ishmael, can I just add something? Because this reminds me of a recent private mediation that I did a few weeks ago, where both parties were represented by attorneys. And one party was a very elderly woman who was highly averse to technology. So I think as mediators, we also have to be flexible. And so because she and her attorney did not want to meet online, they asked if they could call in. And I said, fine. But the other party and their attorney did want to meet on Zoom. So I was on Zoom with one party who was represented, and I was on the phone with the other party who was represented. And so as mediators, I think we have to learn how to be, learn how to adapt to people's situations and their preferences. And that mediation resulted in a settlement of a very high number, and it was not traditional.
Thank you, Tonya. That's a demonstration of how we use the technology in a hybrid form, actually, in order to do our mediation. Great example. Thank you.
We could actually spend about 3 hours deconstructing that one experience and tying it to all other things, but I will spare you going down that road now. But there's a lot of richness in this topic, and it's richness that's not about technology, but about how the technology actually greatly enhances our ability to connect in unexpected, very human, and sometimes very almost primal kinds of ways, as opposed to a barrier.
Yeah. Thank you, Roger. Continuing with the example of CRT here real quick, so we can get to question and some rich discussion. Once the case is submitted, the machine itself is making some decision in terms of diagnosing the dispute, providing free legal information through customized templates, and also allowing you to fill out the online application, pay a fee normally on the real estate dispute at about $125. Again, 125 Canadian dollar for this program, which is, given the market, is very reasonable in terms of fees within the structure, that the program operates in at the national level in Canada. It is an extremely reasonable fee, considering if one has to go get an attorney or even hire private mediators to do those cases, that is very inexpensive actually in order to conduct that the process of dispute resolution. And in most cases, CRT will serve the other party with a dispute notice once the first party, P1, is able to provide the information for P2, such as an email address that the notice can be sent to. And then, of course, CRT will give you a verification that the other party was served. And keep in mind, it's all happening through the machine, no human involvement. So if you're named as a respondent in a CRT dispute, then you need to respond. That is what you've been asked to do. And this gives you an opportunity to go ahead and explain your side of the disputes. A negotiation will follow once all the parties have responded, assuming that everyone has. There's an opportunity to negotiate. And you can try to resolve the dispute by talking it out and coming to an agreement. And the exception of it with CRT has to do with a minor injury determination in motor vehicle injury disputes. If you cannot resolve the dispute by negotiation, this is where a case manager will come in to help you, to help each of you reach an agreement by facilitation, by mediation. And then if an agreement is reached, then it can be turned into orders and it can be enforced like a court order actually through the CRT in Canada. Again, there's exception determination has to do with the motor vehicle injury. Getting a CRT decision, if you cannot reach an agreement by negotiate facilitation, an independent CRT member will make a decision about your dispute, more of an arbitration. Again, it could be enforced. A case manager will help you prepare your evidence of submission to the CRT member for consideration. The CRT member will make a binding enforcement decision then. So that's beyond the machine going to a CRT member, which are, again, qualified, certified mediators who are handling those cases. Here, a question came up earlier, and I'll be sending, I don't have the link on the slide, but the information comes from the CRT Annual Report 2019 to 2020. This is a very extensive report with all the detail, which answered the question that came up earlier, and I'll be glad to share that again. I've made some notes to send out some information and link to Mangari, and if she's kind enough, she can distribute that among all of you. And from that CRT annual report, as you can see in 2017, the last sentence, there were 49 disputes. But look at the number of jumping. I'm going to go from the bottom up to whereas in 2018, you know, from 49 in 2017, it went to 2,441, a massive jump in a very short period of time. And of course, that number in 2019, the number of disputes went up to 5,930. These are disputes that were closed by CRT. And of course, from April of 2019 to March of 2020, they closed 6,079 disputes. I'll be glad to share this report for you, which answer all the detailed question about how the number were calculated, how many cases actually they receive, with all the percentages, with all the charts and graphs. I'll send a link. Please do go through it. It's quite interesting if you have any interest. So on the ODR beyond, go ahead, please.
Kamutai, and if I mispronounce your name, please correct me. Put a question in the chat about CRT that before you move on, I just wanted to address. Is the entire CRT process automated? And depending on exactly what you mean, my answer is mostly yes, because you access it entirely online. There are definitely points where you're connecting with real people, having live conversations with real people, and I think they call you. They may use telephone and Zoom. So it's as online as much as to me, the maximum meaning of that phrase. It's completely automated from my standpoint, but real people are involved all the time. But this is an interesting thing. There is a 90-minute YouTube video out there that I can find a link and send you guys later. After the first year of the operation of the CRT, the systems designer and some other people got together and did a presentation on the results and what they'd learned. And it's full of interesting stuff. One of them was so now the CRT operates in British Columbia, which is a province of approximately 6 million people. And the CRT is what we call small claims court in the United States, civil resolution. It's where people have small disputes involving smaller amounts of money, and they don't have lawyers. And so there's tons and tons of those kinds of disputes. And there was an assumption when they got rolling that there would be a significant number of people who wouldn't be able to access it. They, in fact, greatly overestimated that problem. So they made allowances for people to be able to email into the court the way they always had done. And of course, they could come down to the court and file paperwork if necessary. And here's what happened. They were absolutely astonished at how little, the same number of people accessed the court system or the system as before the CRT automation began, and only a tiny number of people used the email system or came down. I mean, there was less than 100, as I recall, total. It may have even been less than 50 in a year in a province of 6 million people who actually didn't use the CRT to access it. So it's very suggestive. And I'm getting kind of far afield from your question, but I have noticed there's a tendency, particularly among the legal profession, to assume that the problem of people not being able, if they don't have access to internet, that's a separate problem. But this idea that some kinds of people, whether they're older or are less financially able, that they are somehow just not savvy to using online system, I think that's an unfounded stigma. And there are definitely people who don't find these systems friendly, but they're not any one particular demographic or age group or cultural group or anything else. They're all across the board. So I'll stop there because I think I'm digressing too much, Ishmael.
No problem. We've got a couple more slides left. We'll review that with you real quick, and then we'll open it up to question and comment. Of course, how to use Zoom and how do we get our clients to start using the platform is a subject of interest that we definitely want to expand on a little bit more once we're done with this. A couple more slides here. Just real quick, beyond Zoom, ODR, what technology will you create to adopt your ODR system, and what will you standard and ethical process has to do with the old saying that the best way to predict the future is to create it. Therefore, for those of you who have an interest, who are pioneer in the field, there is a great opportunity to not only use the existing platform, adopt it to your environment, but also create your own ODR. It's an open field. Really, there are no restrictions. What works best in one place may not necessarily work in other. That's why a lot of these platforms are very adaptable, very changeable, but at the same time, you have the opportunity to create your own ODR system. There are really no limitation. Again, that doesn't mean because it's the greatest technology that everyone's going to adapt it. The market may not be ready for it at the moment. So we have to make sure that the technology that we're introducing, also the end user, the customer, the client, also have the ability not only to access it, but be comfortable in using it. Although there are many wonderful programs out there, platform, the market may not necessarily be ready for it. So we have always keep that in mind. ODR is actually ADR plus the existing technology, not the future technology, but existing technology. And that's what makes ODR success. Where can you go for guides or assistance? Naturally, if you do an online dispute resolution search on Google, you're going to get millions and millions of articles. There are tons of resources out there. Few of them are National Center for Technology and Dispute Resolution, the almost 100 ODR providers, and web content accessibility guidelines. Again, I'll be glad to share those links with you as well. So what I'm going to do, go ahead and do the stop share of the screen, because that's all I had. I see our chat has been, I didn't have access to chat, but I can see that we've had comment. Thank you so much to my colleague for moderating the chat while I was busy talking. Let's visit the question real quick of, for us, how can we become more comfortable with Zoom, and how can our clients become more comfortable with Zoom? If any of you have any question or comment on that, we'll welcome that. We open it to conversation before proceeding with other questions. Anyone? Please go ahead.
Yes. Thank you. This is Kimutai. I'll make it easier for you. I'm actually usually use the name just Kim. So,
oh, okay.
Roger, you can find that quite easy. When I asked about whether the ERT process was automated, I was obviously watching that video without the sound, and the impression I got was that it was a quick number of steps which had built-in responding to whatever you put forward. Now, then you also mentioned that at the end of the day, the mediator can come in and render a decision. Now, I didn't quite get that, because I thought the whole essence of the mediation was that people come up and drive their own solutions. And that seemed to be more of a judicial system rather than a mediation system. So that just maybe you can clarify that. My understanding might not have been correct.
Sorry, maybe I went
through that,
through
Ishmael, or?
Yeah, just let me quickly address, and then Roger, you can add to that. But quickly, let me say it is automated. Maybe I went through this slide a little too quick, but there was a point where CRT actually can render its decision. without the involvement of a facilitator. However, if a decision cannot be reached, the machine cannot make a decision, make an agreement, then it can be referred to an outside, a facilitator, who's going to continue in the negotiation. Go ahead, Roger.
Well, I'll just add to that a little bit. It's an incremental system, and the first level is what we call, accessing self-help tools. So if somebody just needs, if they have a dispute, but they don't know how to write the other side and, say, send the money in a kind and professional way and to lay out a case, the system provides form letters and things. And then the next level is a consultation with someone, just kind of like an ombuds moment to talk about things. They get a little coaching and they go off. Then there's a request for mediation, and there's a mediated experience. And then, and you're right, Kim, the CRT is part of the judicial branch of government in British Columbia. And for cases that are unresolved and where people, effectively, literally filed a lawsuit, even though it's a small claims matter, people want a result if they can't figure it out on their own. So there's a kind of arbitrated result at the end available, or that will happen if the parties don't sort it out. But it's incremental, and people pay as they go, very affordable fees to go to the next level. If that answers your question. I think Christina was trying to say something too.
I wanted now to follow up because it just brought to my mind. So if the person is going to come up with a decision at the end of the day, is he or she privy to all the discussions and the, should we say, concessions and everything else given during the process? Because it seems to me that if you are going for a judicial outcome, you would only present your most favorable approach. Whereas if I've already made concessions in the course of trying to get the thing settled, and that is used against me, it can actually cause. Sorry, that just came to mind. I hope you can.
Oh, that's a fantastic question. I'm so glad you answered it. Unfortunately, I can't answer it with 100% certainty, but I believe there's a separation from the mediated conversations, which contain stuff that are confidential that somebody wouldn't want to use in an adversarial setting, right? So I think that if the mediated event doesn't solve the problem, I think then the matter is handed off to still another party who approaches it from the perspective of an arbitrator, and everybody has to submit stuff over again. I'm pretty sure that's how it works. I'd have to verify it. There's lively dialogue on this topic in North America. There's an emergent field of kind of a combination mediation arbitration, where the mediator can basically be asked to continue and give a decision. And many arbitrators have persuaded me that that's not such a good idea for the very reason you raise, because especially if it's the same person, making the decision, well, their process is kind of corrupted by hearing all these things they wouldn't have heard in a normal arbitration. So it's a very interesting area, and it's developing.
So, Roger, I said I was a part of that mediation arbitration panel with the 24-hour presentation that we did with Mediate BC. And that question came up, and a lot of times they have agreements in place ahead of time for this reason, to, kind of make sure that there's no bias there. So they sign agreements sometimes in advance saying, if we go forward with arbitration, will we use the same person? That was also the mediator. So a lot of times they resolve this in advance, and if they go forward, they will not use the same person.
Thank you. Christina, were you trying to offer a comment or ask a question?
Yes, thank you. I'm just asking for currently we are at a level
We may have lost Christina. Has to do with the bandwidth.
Yeah.
We'll see if she joined back in.
Well, let's give her a minute to sign up, and I want to take a moment and acknowledge that it's late in the evening where you folks are, and I so appreciate you hanging in with us when you're tired. If Christina's back, let's see if we can connect with her.
Okay, thank you. I think that's an example of what happens. We have these challenges in, the network and all that. So we are young in this, and we are growing, and we are embracing it because really is the only way to go so far. I was saying that it's like we've just been thrown into it. We just found ourselves into it, especially with this period of this pandemic, with the lockdown and everything. You find that we found ourselves in a situation where there is no other way to do it. We just have to do it because, cases are there, disputes are there always. They are rising, and there are even new disputes, new kind of disputes which have not been before, which have come in as a result of the pandemic and the lockdown. So you find that for us, it's something which we've been it has come in, and we just have to take it. We have no otherwise. You see, no other options. From my point of view, and from my experience as a trainer, I think we from what I'm also getting from you, because you've done it before, you've gone earlier before us. We've actually been learning about how you do it and how it started with you. Maybe you could give a comment on that, how you started. And from a trainer's perspective, I think that we need to put it, to introduce it in our curriculum on a very serious note. Initially, it wasn't so much, so much of it, but now it's something that we have to incorporate in the curriculum to upgrade the skills of mediators, especially in ODR. For me, I've done it as a matter of interest, and it's not easy, but I'm getting on it. And in the training aspect, when we introduce it in such a way that it becomes part of the training, I believe now the mediators will find it much easier. Because, there's that kind of fear of new, the fear of new things. Now, we used to do things this way. Now we have to change and do them the other way. I don't know how to go about it. So it discourages people. So just you can comment on that from the training perspective and how that could assist us. You see, as a country which is young in this ODR in terms or with regards to mediation. Thank you.
Thank you so much, Christina, for the question and comment. The way it was done in the US in order to bring people up to par, naturally, society operates a little differently, which is competition drives not only technology, but technology also drives the competition. In other words, what I'm trying to say is that a lot of the organization went in to look at the training with a challenge on hand and turn that challenge into an opportunity. It is something you can easily do, which is requiring the online mediators to become certified. In other words, if you are not certified, then perhaps you should wait before you get into the ODR. Now, that certification is going to be a training curriculum, to where it's going to take the mediator through the process of, for example, becoming very comfortable with Zoom, on a continuing education of Zoom, practicing together, to do breakout room, to do caucuses, to learn all the features. And as a result, through certain curriculum, certain number of hours training, then they become certified. They have a certification badge, and only they are authorized, once they've gone through the program, once they're certified, to be able to conduct online mediation. That is an option. That is one option that can resolve by taking a challenge, turning it into an opportunity. We are isolating, but at the same time, you're encouraging the others to join in and get certified so they can actually be more comfortable and have the status in order to conduct those type of mediation. Because certainly there is a difference between face-to-face and this online. We have to be more attentive. It is more exhausting too. This is what we find. And it is going to lead to what we call self-care. So now that we are introducing all this pressure, what are we doing for the mediators in terms of their awareness? What are we doing in terms of reflection, the self-reflection, reflection before action, reflection during action, reflection after the action itself? And what are we doing in terms of our best practices? So you see at CIS, and that's the topic of December 5th, which I encourage all of you not to miss. At the same time on December 5th, we'll be doing the talk of CIS and how we do things in a very holistic approach. So you cannot just have one component of requiring certification without missing the other components of self-care, of reflective practice, and also best practices for mediators to have a platform where they can share experiences, move forward, and also reflect on experience in a very confidential, non-judgmental environment. Because for us, it is a learning curve. And, we still, this curve is still growing. It hasn't plateaued quite yet, even in the US. Because by the time Zoom plateaus, then there's the introduction of a whole new technology that is going to be in place. And we have to embrace ourselves to be ready to train ourselves. So who do we have in order to do that? When it came the time of COVID for us in March, we have each other. The other people called on us to be able to jump in and help out, to bring people up to par, to certify them, to get them on board. And we required 2 different sessions of Zoom for our mediator. One was the beginner, one was the intermediate and advanced. So we conducted those training, we got people up to par, we got them comfortable with the technology before they actually were able to get on the Zoom room and actually be able to conduct mediation. I don't know if anything else my colleagues have to add to that.
I was putting a long statement into the chat, but which was to share that we, Ishmael, Tonya, and I, we all engage in regular online best practices activities. There's a number of groups that hold these events by Zoom, and they've been amazingly beneficial for all of us. The most experienced people with Zoom have been learning the most when COVID started from the people who'd never used it before. And they brought all these incredible questions. And so we kept doing these things. The Canadians do one every couple of weeks, and then we have one in San Francisco. And I was just putting in the chat that we could communicate with anyone who's interested where you are in setting up a program like that. And if we did it real early in our day here, it wouldn't be so late for you. So something to think about, but practice, practice, practice. There's an amazing number of just issues. I think they're very interesting too. Like, for example, how do you change your confidentiality agreement, add a little bit language so it covers things you're already doing now that you're not thinking of that should be explicitly referred to in a confidentiality agreement. So we have a provision that starts out with there'll be no recording or broadcasting. And then there's a list of technologies, including telephone, email, and texting, that to make sure that those things are explicitly mentioned in the agreement as being covered by confidentiality. Then when we meet with people, we remind them and we ask them, we go around the room, so to speak, and say, please nod your head or say yes, that you're not recording this on your phone, or that there's no one in the room that we can't see. So these are really very simple best practices. There's like 30 pages of notes on this subject that have been created over the summer by the group in Canada. So I would just encourage everyone to keep asking questions and keep practicing and look at this like all elements of your mediation practice as a practice.
Yeah. And also not to forget what Bangori brought up earlier on the second part of her question had to do with how do we encourage our client to use the technology. It is not an easy task. Even with access to technology, for example, in the San Francisco Bay Area, we find ourselves with our stakeholder when it comes to real estate vertical, that many of their tenants don't have access to technology. So what they're doing as property manager, they're making a room available, a private room, to whereas tenant is able to go ahead and get on the computer and be able to conduct their Zoom session. So in other words, it is a partnership with the stakeholders to make sure that they use their resources and make it available to the client so that the client actually will have access to technology. At CIS, we have distributed iPads to different entities. So for people who don't have access, they can actually use those in order to connect with us. Telephone, a smartphone is something that, pretty much in our area, everybody has access to. And we have adapted by using that technology of not only conversation on phone, but also text in order to communicate with them. So it's not much that they have to adapt to what we have. It has to be Zoom. It is more of how, as Mediator, we're adapting to the technologies available to them in order to be able to serve them. And this brings us back to the very beginning of Nelson Mandela with the, the leadership of servant leadership. That's what it's all about, is to be in the service of others. To do that, we cannot simply impose what is available to us, but we have to adapt to what is available to them and be able to serve them. And that's what we have always to keep in mind.
What,
Roger?
I love that. May I chime in and just add something to that, Ishmael?
Please do.
Something I forgot to say, and Sabina, I think you may be particularly interested in this. We work with a lot of very vulnerable and traumatized people in our program in San Francisco. That's essentially a tenant-landlord negotiation or mediation program. Many of the cases, by the way, it's neighbor-to-neighbor conflict that is where they're disrupting a community. So it's tenant to tenant or neighbor to neighbor, but they may lose their home if they can't stop acting out in the way they are. And some of these people are just, as I said, traumatized, and they don't want to be seen on video. They don't even want to be in the same virtual space in a telephone call. They're terrified. They're hurt, and so we meet them with right where they are, just like we always do in mediation, trying to meet people where they are in the broadest sense of that expression. So that's where the asynchronous or shuttle negotiation comes in. So there was one case that I was involved with personally, where I happened to meet a young transgender individual when I was visiting a community and did a little 5-minute talk about our program. And when I met him, we didn't know who we were. I hadn't spoken yet. We were just at a table, had a cup of coffee and visited. And, we just talked and were kind to one another. And 3 weeks later, I got an email from him asking me for help. And what developed was he had a situation that was very serious, that needed dialogue with a property manager and a case manager and somebody else. And he could only communicate with me in writing, by email. They always came in at 3 o'clock in the morning. And instead of treating that as a barrier, I just embraced it. And I just carried his messages, and I accepted that he wasn't able or willing to get together. That's okay. So my job then was to get the other side understanding of that. And it didn't take long to do that. And then we had a conversation that ultimately ended up with a written settlement agreement that addressed all the issues. So I'll stop there. If anyone has questions, I'd be delighted to answer.
So on a time check, we have about 17 minutes left of our session. Again, we appreciate really you being here. We realize you've had a long day. You're not the only speakers today to have conversation with you. You've probably been through a few sessions. It's late for you. So we are grateful for that. And if there are any questions we can respond, please, let us know, because it's a learning for us as well. This is also new for us. we don't see much distinction really between person to person and ODR because of our compassion, because of our empathy. And that's something, through our practice at CIS, that's something that the people that we work with, the help request that comes in, they feel that they get it, that we are here for them, that we're here to serve them. So we understand the challenges. We're willing to work with it. We are patient. If we lose you, we'll hang in there for you. You'll come back to us. And we work with you in order to continue the dialogue. That is being very neutral, not just for one party, for all parties that are involved, to make sure they get it, because we are advocating for process. Kim, go ahead, please.
Thank you. I think we're at the stage where I can make a comment or observation, and it can be answered or not answered as the case is. We have a lot of problems along the lines of what we've talked about before. Some of them have to do with communication, others have to do with equipment. I have realized, even working in a relatively stable environment, that I have to have a backup for my Wi-Fi. And then I also have to have a UPS to keep the battery going, because we also tend to have sometimes a power outage. So the last thing you want to do is to vacate a room and leave the clients talking to each other without you being there. So these are all challenges which we have faced. I think, I only started working with Zoom after the beginning of the pandemic. So it has escalated a lot with the mediation fraternity. There have been moves with Strathmore University and our panel, which has actually undergone training sessions with the mediators to try and teach them. One of the things which has come across, especially as I listen to a lot of what you're saying, is that the tools at our disposal are moving faster than we trying to catch up. And I think as mediators, some of this is just the Wild West. We're making it up as we go along. I remember when we were talking about, in one of the sessions, about confidentiality. And I said, well, look, trying to get people to sign a mediation agreement when it's difficult enough for them to understand how to operate Zoom. I said, what happens if we said, let us suspend the recording aspect and only record the agreement to mediate, where everybody can be on camera and say, yes, we agree to that. And maybe we can also record the settlement. And when I ask people, what is the problem? The problem is with recording confidential aspects. When you're recording aspects of agreement or aspects where you're actually consented to, it seems to me to be in order. But now we also have to be very careful as we use these tools at our possession, in our possession, that we don't conflict any of the ethical boundaries and guidelines, etc. So it's also very interesting to be able to exchange views with people from widely differing backgrounds. Yeah. So I really appreciate it. And I don't know if there was a question inside there, but
yeah, Kim, Roger responded by saying, yeah, we don't record our Zoom session. If we do any in our training, we definitely want to make sure it's unanimous consensus in order to do that. That is important. Roger, go ahead. I know you want to add more.
Yeah, there's what you first said, Kim, about it's almost like we're in free fall in a way. There's so many things happening. We don't even know what we don't know, and that's why these group practice sessions are so wonderful. So someone in a session just happened to mention in one of these practice group sessions that they were recording their Zoom meetings, and they thought that was a really nifty idea. And it was actually, I think, well, it doesn't matter who pointed this out, but the one very technical problem with that is that the recording doesn't live on my computer. It lives in a server controlled by other people that are accessible by other people. So in theory, those same people could be watching what we're doing right now, but if they're recording what we're doing without our permission, they're doing something illegal. And I'm setting aside jurisdictional issues. But the fact that I'm keeping a complete video an audio record of a confidential conversation and handing it over to a third party is by definition breaks mediation confidentiality. So nobody I know is recording Zoom sessions for mediation now in our orbit, although I can imagine sometimes why that might make sense. There's other things that are just there are things, for me, this topic area is another pointer not to how ODR is different, but how it's no different than regular mediation, because there are issues in regular mediation we just don't think about. A power can go out in our building where we're holding a mediation at night and we have to light candles. That's an example of being ready to adapt. Of more interest to me are what things that are going on that we don't think about, like in-person mediation, a big one with a bunch of lawyers and maybe a bunch of business people, and maybe there's decision makers in another part of the world that they have to communicate with before they get to yes. There are people in those meetings right now as we're speaking, who have an iPhone in their pocket and they're recording the meeting in violation of the mediation agreement. Well, similarly, things can happen when you're using Zoom. It's not just because it's Zoom, it's because of what's happening with the parties. So that's why, and you can't control people. I can't stop people from recording with another device, but by calling it out, by putting it in agreement, by revisiting the issue before you start talking, you're adding additional protective measures so those things can't come back later to hurt people. There was a situation in Canada that really chilled me. And this was actually an in-person session before COVID started. It was in a community mediation center, and it was some sort of family dispute. And there was a number of people involved, and they had a bookshelf in a conference room where everybody put their purses and bags and hats and things, and phones. Well, one person propped their phone up, pointing it at the conference table, and started a live stream on Facebook. Nobody figured out the entire process was beamed around the world, accessible to everyone. That's when the mediator that happened to, Amanda Semiroff in Canada, that's when she came up with putting the word no broadcasting in the mediation agreement. So there's a lot of things that are pretty scary, but when I remember, I'm powerless over most of it, and all I can do is the best I can to create a framework and remind people to honor the things we've agreed to. You know, that's all I can do. So I do it and I move forward.
Thank you, Roger. We have two hands raised, Vangori and then Pauline. But before we go to Vangori, just quickly, what we do with confidentiality, we get it taken care of ahead of the meeting. So in other words, when we are in the meeting, we already taken care of it. So we've emailed it, they have signed it, they have sent it, we have it in file. So that part is being taken care of ahead of time, if that helps. Vangori, please go ahead, and then Pauline after.
Okay. Yeah, thank you, and yeah, for the discussions. One of the things that I really take away from this session today, and I think that's what Ismail was trying to get us to grasp when he ran the video that had Nelson Mandela, is compassion. And I think for me, even as you've gone through this session and all along, it's still around technology, or the technology part of it was supposed to be the core. What I really just get is that it's about compassion. Then that will make, let me say, will make me work around things, will make me and my colleagues with other peer mediators work around things. And so what I'm hearing, even as we talk technology, is that humanity is the core of it. And here, when you talk about humanity, the persons who are in dispute, it's still back to what we were trained. That's someone doing a call, a cry for help. And the cry for help, then it just happens that it will probably be on a platform that is not what they were used to or what I have been using before, but it's still back to humanity. So that's my takeaway for today. Thank you, Ishmael.
Thank you so much, Vangori. I could not have articulated that any better, because really that's what it's all about. I mean, technology, ODR is just an excuse because bottom line, it is us. It's that servant leadership. It's being there for others. Doesn't matter what the details are. I mean, a car can break down on the way to mediation. you have to figure out a way to get there, right? The light can go out in a room in mediation. So it really comes back to us, who we are, what we do, and why is it doing what we're doing. And that's why we started with Nelson Mandela to sort of remind ourselves again, you know, peacemaking, humility, really, that's what's all about, and compassion, putting ourselves in their place, what their needs are, and empathize with them. Thank you. Pauline, please go ahead.
Thank you very much, Ismail, and thank you very much for that informative section. My question is, as somebody has said in the now that the training of mediators, maybe all over the world, has to give us some more tools, and it should change, because now there is, the infrastructure is changing. I don't know what is your take. You are in the first world, we are in the second, we are in the third world. Now, you see, there is some limit I cannot go beyond, the connectivity of internet in the rural areas. There is nothing we can do about that. That's why I deal with only the people who are in the cities, who are in the towns. But we still need to go, as Wagari is saying, is about compassion, is about, you know, trying to bring harmony into people. Now, there is a way. What do we do? Because now going to the rural areas, there are people who don't even have the telephone. They don't have the smartphone. They don't, the internet is very poor, but they need our services. At the same time, I can't use the Zoom. You know, I personally have used the Zoom. I didn't know, I didn't record, but I didn't know if the recording can go haywire. You know, everybody can change the whole thing and go very bad. So these are the things now I think we need now to bring into the training. Or what are your organization thinking of how to bring these, to make it better for everyone, for humanity, so that everybody, the confidentiality still stands, as much as the challenges are there, as much as we are embracing the technology, as much as we are not meeting face to face, definitely there is a challenge. What is your take on this? Thank you, and thank you very much for this. I have learned a lot. Thank you.
Thank you, Pauline, and forgive me for my ignorance. And thank you for reminding me, you know, grounding us. Thank you for grounding us again. We definitely will not forget you, because we talk with people. There are a lot of people in the world who want to do a lot of good. As we continue the conversation with others, with our colleagues all over the world, we'll let them know of your message, and we'll ask for help for those people who need the bandwidth, with some hotspots, with some technology that can help for us, for you to reach them. So please continue asking. Do not stop asking. You never know who's in the audience and who is willing to reach out and be able to provide you with what is mostly needed. I shall ask.
Well, Ismail?
Just for 1 second.
Ismail?
Yes.
Okay, one minute, please.
Sure.
Please,
yeah, I wish to comment on that, Ismail, because as a trainer and from the background of a trainer in mediation, as you said, we would learn a lot from you on how now to enrich our curriculum, so that we can give our mediators what the tools that they need, you know, and those who are already trained to upgrade their skills. So I think that's an area that would really benefit from you now that you are ahead of us. Roger and Ismail will appreciate your support on that. And we are just about to wrap up. Maybe one more comment. Ismail, Roger.
Thank you so much. Our colleague Tonya was going to add something. Tonya, please go ahead.
I was just going to say, for just in the San Francisco area, we also have housing units who don't have adequate bandwidth and technology. And we ran into that problem, even though it's, you know, America and it's a big city, there's still areas where they're underdeveloped. So we ran into those problems as well, voiced the concerns and got people to donate so that individuals could have access. I just wanted to bring that out.
Thank you. And we'll let Roger wrap it up for us. But before doing that, I want to say thank you. Thank you for the opportunity on behalf of myself and my colleagues. Thank you for being with us. We have 2 more sessions with you. If you would like to be there with us, we'll provide more information. And definitely, if you miss Wednesday, do not miss Saturday. That's a very good session in terms of what we do at CIS. You know, the guiding principles, how the program is started with Roger himself. You have the man with us, so do not miss the opportunity. Roger, please, if you can close it for us, I would appreciate it. Thank you.
Well, thank you, Ishmael and Tonya, for putting on this presentation today. Thank you so much, Wangari, for inviting us, and all of you for being here. And all I can do is express our gratitude, and we look forward to seeing you on Wednesday, on Saturday, if you can make it. On our next session, we're going to talk about, you know, how to business aspects of being a mediator and trying to pay one's bills while working as a mediator. And it's going to be a very personal discussion of each of us, how each of us has a private practice in addition to the work we do with this program in San Francisco. Each of us needs that to pay our bills. And so we'll talk to you about those things and look forward to any questions that you have. So please think about it, and just bless you all very much. And I can't tell you how much it means to me to be a part of this group tonight, your time.
Thank you, everyone.
Thank you very much. Thank you.
Thank you.
Thank you. We close with our national anthem. One stanza of our national anthem. Kim Tai and others, you could assist. We go. Okay, there it is on the screen. Okay, we do the English version. Okay. Oh God of all creation,
bless our land and nation.
just be our
shield and defender.
May we
dwell in unity,
peace and liberty,
be found
plenty be found within our borders.
Thank you. Thank you, Roger. Thank you, Ismail.
Thank you.
Thank you.
Tonya.
Thank you very much.
Good night.
Good night. Thank you.
Bye-bye.
Good night and good day, good afternoon.
Good day. Thank you.
Good day. Thank you.
Good afternoon to our presenters.